We are standing at what could be the most important moment for gun rights in over a decade, and most people have no idea it's even happening. Right now, as we speak, two major cases challenging rifle bans and magazine bans are heading toward the same Supreme Court conference scheduled for February 20th. But here's what makes this different from every other time we've talked about the Supreme Court potentially taking up a gun case. These two cases won't be alone. Multiple other rifle and magazine ban challenges from different states and different circuit courts are all lining up for that exact same conference date. We are looking at a perfect storm of Second Amendment cases, all landing on the Supreme Court's desk at the same time asking the same fundamental question. Are AR-15 style rifles and standard capacity magazines protected by the Second Amendment, or can states ban them? This is the scenario that many legal experts and even some of the justices themselves have been hinting at for years. Instead of taking one isolated case from one specific state, the court can now look at multiple bans from multiple circuits with multiple conflicting rulings all at once and finally address this issue nationwide in one comprehensive decision. Let me walk you through exactly what's happening, why this moment is so critical, and what it could mean for gun owners across the entire country. If you've been following Second Amendment issues for any length of time, you know the Supreme Court has been avoiding rifle and magazine ban cases like the plague for years. The core question they need to answer is actually very simple. Does the Second Amendment protect commonly owned semi-automatic rifles like the AR-15, and does it protect standard capacity magazines? Right now, lower courts across the country are deeply divided on this question. Some courts say these rifles and magazines are protected arms because they're in common use for lawful purposes. Other courts say they can be banned because they're too militaristic or too useful for military service. And some courts say that even if they are technically protected, armed states can still ban them anyway under certain circumstances. That confusion and that mess of contradictory rulings is exactly what these cases are asking the Supreme Court to finally step in and fix. The problem is, the court has been ducking this issue for years, but now with multiple cases converging on the same conference date, they may not be able to avoid it any longer. Let's talk about the two main cases that are leading this charge. The first one is called Vermont versus Cook County. This case challenges Cook County, Illinois' ban on so-called assault weapons, which includes AR-15 rifles and dozens of other commonly owned firearms. And the plaintiffs in this case are making a straightforward argument. These rifles are in common use by millions of law-abiding Americans. Under the Supreme Court's own precedent in cases like Heller and Bruen, firearms that are in common use for lawful purposes are protected by the Second Amendment. Therefore, states and counties cannot ban an entire class of commonly owned firearms just because they don't like how they look or because they have certain features. The plaintiffs are asking the Supreme Court to say once and for all that you cannot ban guns that millions of Americans already own and use legally. The second major case is Duncan versus Bonta, and this one deals with California's magazine capacity ban. This case has a complicated history. It was actually granted review by the Supreme Court once before, then vacated and sent back to the lower courts after the court issued its Bruen decision in 2022. The idea was that the lower courts should reconsider the case in light of Bruen's new historical tradition test. But here's what happened. The lower courts looked at it again, and they still upheld California's magazine ban despite what Bruen said about how these cases are supposed to be analyzed. So now the case is back in front of the Supreme Court again, because the lower courts basically ignored what Bruen told them to do. This case is asking the court to clarify whether states can ban magazines that hold more than a certain number of rounds, even though those magazines are in common use by millions of gun owners. Now, here's where things get really interesting. Both of these cases have been relisted multiple times by the Supreme Court, instead of just being outright denied. That's actually a very significant detail. When the Supreme Court relists a case, it means the justices are actively discussing it behind closed doors. They're not just dismissing it, they're talking about it, debating it, and deciding what to do with it. Cases that get relisted once have a much higher chance of being granted review compared to cases that are just denied on the first conference. But cases that get relisted many times can go either way. Sometimes multiple relists mean the court is preparing to deny the case, but maybe with a dissenting opinion from some of the justices. But other times, multiple relists mean the court is lining up cases together for a coordinated grant. In other words, they're waiting for other similar cases to arrive so they can grant review to multiple cases at once and address the issue comprehensively. That's exactly what appears to be happening right now. Based on the court's calendar and the pattern of relists, both the Vermont case and the Duncan case are now likely heading to the February 20th conference, and multiple other rifle and magazine ban challenges from different states are already scheduled for that same conference. This creates something we have not seen before. You're going to have multiple cases on the same constitutional question landing together in front of the Supreme Court on the same date. Here's why this is such a big deal, and why this could be the moment that forces the court to act. This is exactly what many of the justices have been suggesting they've been waiting for. Instead of taking maybe one case from one isolated state with one specific set of facts, the court can now look at rifle bans from Illinois, magazine bans from California, and other challenges from other jurisdictions all at the same time. They can see how different circuit courts have ruled on the same issue. They can compare different types of bans. They can address multiple legal arguments all at once. This allows them to issue a comprehensive nationwide ruling that resolves the confusion instead of just answering one narrow question from one state. It also potentially avoids the problem that's come up before where the court says a particular case isn't the right vehicle because of some procedural issue or because it doesn't present the question cleanly enough. When you have multiple cases dealing with the same core issue, you eliminate that excuse. If one case has a procedural problem, maybe another one doesn't. If one case doesn't present the question perfectly, maybe another one does. The court can pick the best vehicle, or they can grant review to several cases and consolidate them for oral argument. This is now shaping up as a coordinated moment where the Supreme Court can finally answer the questions that gun owners have been asking for years. Are AR-15 style rifles protected arms under the Second Amendment? Are magazine capacity bans constitutional? Can states ban entire categories of commonly owned firearms and magazines? After years of avoidance, we may finally get definitive answers. Let me explain what the relist pattern tells us, because this is important. Both the Vermont case and the Duncan case have been relisted multiple times now. Historically, we know that cases relisted at least once have a much better chance of being granted review. But when cases are relisted many times, it can mean different things. Sometimes it means the court is still debating internally and they're not ready to make a decision yet. Sometimes it means they're waiting for more information or waiting for other cases to catch up. And sometimes it means they're preparing to deny the case, but there's going to be a dissent from some justices who wanted to take it. We've seen all of those scenarios play out before. But here's the key detail that makes this situation different. We've also seen major Second Amendment cases get relisted a huge number of times and then still get granted review. The Bruen case itself, which is now the most important gun rights decision in over a decade, was relisted many times before the court finally granted it. The Cargill case about bump stocks was also relisted multiple times before being granted. So multiple relists are not a death sentence for a case. In fact, in the context of Second Amendment cases, multiple relists often mean the court is taking the issue very seriously and they're trying to figure out the best way to address it. And when you combine that pattern with the fact that multiple other rifle and magazine cases are all heading to the same conference, it starts to look less like the court is trying to avoid the issue and more like they're lining everything up for a coordinated grant. So where does this leave us right now? We have the Vermont case challenging rifle bans, likely heading to the February 20th conference. We have the Duncan case challenging magazine bans, also likely going to that same conference. And we have multiple other rifle and magazine ban challenges from other states already set for that conference date. This is the perfect storm. All of these cases are focused on the same fundamental constitutional question, and they're all going to be in front of the Supreme Court at the same time. If the court grants even one of these cases, or if they grant several of them together, we could finally get a definitive ruling on whether states can ban AR-15 style rifles and standard capacity magazines. The ruling would have nationwide impact. It would resolve the circuit splits. It would give lower courts clear guidance, and it would finally answer the question that's been hanging over gun rights for years. After all the delays and all the avoidance, this could be the moment where the court can no longer duck the issue. So what happens next, and what should you be watching for? The next Supreme Court conference that's currently on the calendar is February 20th. That's the key date. Multiple rifle and magazine ban cases are already scheduled to be considered at that conference. If the pattern holds, the Vermont and Duncan cases will also be on the agenda for that same conference. What the court does at that conference will tell us a lot. If they grant review to one or more of these cases, we could see briefings start in the spring, and we could get a major Second Amendment decision by the end of the court's current term, which typically wraps up in late June. That would mean a definitive ruling on rifle and magazine bans by summer of this year. On the other hand, if the court denies all of these cases, or if they relist them yet again, it would signal that, despite everything they've said about addressing this issue in a term or two, they're still not ready or willing to step in. That would be a huge disappointment for gun rights advocates, and it would mean the confusion and chaos in the lower courts continues indefinitely. Let's talk about what's at stake here, because the implications are massive. Right now, there are an estimated 20 million or more AR-15 style rifles in civilian hands in the United States. Standard capacity magazines that hold more than 10 rounds are ubiquitous. Tens of millions of gun owners across the country rely on these firearms and magazines for self-defense, for sport shooting, for hunting, and for all kinds of lawful purposes. Multiple states have passed bans on these firearms and magazines, including California, New York, Connecticut, Massachusetts, Maryland, New Jersey, and others. Those bans affect millions of people. If the Supreme Court rules that these bans are unconstitutional, all of those state laws would be in serious jeopardy. Gun owners in those states would potentially regain the right to own firearms and magazines that are legal in most of the rest of the country. On the other hand, if the court refuses to take up these cases, or if they take them up and rule in favor of the bans, it would give states a green light to continue restricting commonly owned firearms. It would mean that your Second Amendment rights depend on what state you live in rather than on what the Constitution actually says. The stakes could not be higher. It's also worth noting that the justices themselves have dropped hints about this issue over the past few years. In various dissents and statements, justices have expressed frustration with lower courts not following Supreme Court precedent on gun rights. They've made comments suggesting they would address the rifle and magazine ban issue in a term or two. Well, we're now several terms past those statements, and the issue still hasn't been resolved. February 20th is the test. We'll find out whether those statements were genuine signals that the court was preparing to act, or whether they were just empty words to placate gun rights advocates, while the court continues to avoid the hard questions. The credibility of the court on Second Amendment issues is on the line. Let me also explain why the lower courts are in such chaos on this issue and why Supreme Court guidance is so desperately needed. Different circuit courts have reached completely opposite conclusions on the same question. Some circuits have upheld rifle bans, others have struck them down. Some circuits say magazine bans are constitutional, others say they're not. The Ninth Circuit, which covers the West Coast, has generally upheld California's bans on both rifles and magazines. The Fifth Circuit, which covers Texas, Louisiana, and Mississippi, has struck down similar restrictions in other contexts. The Fourth Circuit, which covers states like Maryland and Virginia, is divided and has issued conflicting rulings. Without clear guidance from the Supreme Court, this chaos is going to continue forever. Gun owners' rights will depend entirely on where they live rather than on what the Constitution says. That's not how constitutional rights are supposed to work. Your right to free speech doesn't change when you cross a state line. Why our right to a fair trial doesn't depend on your zip code. And your Second Amendment rights shouldn't either. But right now, they do. And the only way to fix that is for the Supreme Court to step in and issue a nationwide ruling that applies everywhere. Here's the bottom line and what you need to know. We are approaching a critical moment. February 20th is the conference date to watch. Multiple rifle and magazine ban cases are converging on that date. The Supreme Court will have to decide whether to finally address this issue after years of avoidance or whether to punt once again. If they grant review, we could have a major decision by this summer. If they don't, it means more years of waiting and more chaos in the lower courts. This is the moment that could define the future of gun rights in America for the next generation. After years of delays and after multiple cases being relisted and discussed, the court is running out of excuses. They have the cases in front of them. They have the circuit splits. They have the clear constitutional question. The only question left is whether they're willing to do their job and answer it. Gun owners across the country are watching. Legal experts are watching. State legislatures are watching. And the justices know it. February 20th could be the day everything changes, or it could be another disappointment in a long string of disappointments. We're about to find out. This is the moment of truth for the Supreme Court on the Second Amendment. The question is simple. Are AR-15 style rifles and standard capacity magazines protected by the Constitution? After years of confusion, it's time for a clear answer. And with multiple cases, all landing on the court's desk at the same time, the justices may finally be forced to give us one.